When families begin researching federal relief, one of the biggest questions they ask is this: should we file a 2255 motion, or should we file a 2241 petition? Many people believe these two federal remedies are interchangeable. They are not, and choosing the wrong procedural path can create confusion, wasted time, and unnecessary frustration. In this video, we're going to explain the difference between a federal 2255 motion and a federal 2241 petition using plain English. We'll discuss what each remedy is generally designed to do, why they are often confused, and how the Supreme Court's decision in Jones versus Hendrix changed the landscape for many federal prisoners. And make sure you stay until the end of this video, because one of the biggest misconceptions families have is believing they can simply choose whichever remedy sounds better. Federal law generally does not work that way. Let's start with the basic idea. A 2255 motion and a 2241 petition are both forms of federal post-conviction relief, but they generally serve different purposes. In very simple terms, a 2255 motion usually challenges the legality of the conviction or the sentence itself. A 2241 petition generally challenges the way the sentence is being carried out. Think of it this way. Imagine a road. The conviction and sentence are the destination the court reached. The Bureau of Prisons is responsible for carrying out that sentence. If someone believes something went seriously wrong during the criminal case itself, the conviction, the sentencing, or a constitutional issue affected the outcome. A 2255 motion is generally the federal remedy Congress created for those kinds of claims. On the other hand, if the question involves how the Bureau of Prisons is calculating or administering the sentence, such as certain sentence execution issues, earned time credits, or other custody-related matters, those situations may involve a 2241 petition. That sounds simple, but in practice, it often becomes much more complicated. One reason is that many prisoners hear about successful federal cases from other inmates, online forums, or social media. Someone says, "I filed a 2241. Someone else says, "You need a 2255. And before long, families are left wondering which one actually applies. Unfortunately, the answer depends on the specific facts of the case. Now let's talk about one of the biggest changes in recent federal law: the United States Supreme Court's decision in Jones versus Hendrix. Before that decision, some federal prisoners attempted to use 2241 petitions to raise certain claims that could not proceed under 2255. After Jones versus Hendrix, the Supreme Court significantly narrowed when that approach may be available. That does not mean 2241 petitions disappeared. They did not. And it does not mean every prisoner lost every possible remedy. What it does mean is that understanding the proper purpose of each federal remedy has become even more important. Another common misunderstanding is believing that whichever remedy offers the best chance of success can simply be chosen. Unfortunately, federal courts generally do not allow people to select whichever procedure they prefer. Each remedy has its own legal requirements, its own procedural rules, and its own limitations. That is why researching only one federal case or copying a motion someone else filed can become extremely risky. Every federal case has its own history, its own procedural posture, its own deadlines, its own legal issues. A filing that made sense in one person's case may have nothing to do with another person's circumstances. Another important point families should understand is that neither remedy guarantees relief. No ethical person can promise success in federal court. Federal post-conviction litigation is often complex. Courts carefully review procedural rules, prior filings, applicable statutes, and current legal precedent. Sometimes a case may involve multiple issues. Other times, a person's legal options may be much narrower than they expected. That is why education matters, because understanding the process helps families ask better questions and make better informed decisions. So, how can someone begin thinking about the difference? Ask yourself a simple question. Are you primarily challenging what happened during the criminal case itself? Or are you questioning how the sentence is currently being carried out? That question alone will not determine the correct legal remedy. but it can help explain why 2255 motions and 2241 petitions are generally treated differently under federal law. Remember, federal post-conviction relief is not a one-size-fits-all system. Small factual differences can sometimes lead to very different legal outcomes, and recent Supreme Court decisions continue to shape how federal courts analyze these cases. That is why relying on outdated information can become dangerous. Federal law evolves. New decisions are issued, procedural rules change, and educational resources should keep pace with those developments. If you'd like to learn more about federal post-conviction relief, federal sentencing issues, or other educational federal relief topics, visit apexfederalrelief.com. And if you found this video helpful, subscribe for more federal relief education explained in plain English. Because the better families understand the federal system, the better prepared they are to make informed decisions moving forward.